Hello, everyone, and welcome back to another exciting episode of Immigration and Jobs Talk Show, where we dive into topics that matter to you and everything immigration related. So, whether you're joining us from Facebook, YouTube, or LinkedIn, I'm very thrilled to have you all today here with us. And yes, we are going to have something truly special lined up for you. And today, we are going to be very honored to welcome a distinguished guest who has joined us earlier as well, to share her expertise in immigration law. And definitely, she's simply remarkable. So, joining us is none other than Attorney Prashanthi Reddy from the law offices of Prashanthi Reddy PLLC. This firm, is renowned for seamlessly integrating diverse areas of legal expertise to solve clients' problems, and that is with precision and care. So, without further ado, please help me welcome her. She is going to be shedding light on a topic that is on everyone's mind. So, welcome, Shanti Reddy. Thank you for joining us today.
You're welcome, Nipasa. It's great to be back again and looking forward to today's session.
Absolutely. And you've already covered so many webinars here with Rajani Barara earlier. So thank you so much for doing this today as well. And today we are going to be speaking about unveiling the future of H-1B visas and, of course, the proposed regulations for CAP filings as well. So maybe you could give us a sneak peek, what the viewers can expect from your presentation today.
Yes, so I was thinking that we should cover the proposed H-1B regulation today, simply because there's so much in that proposed regulation. And even though it's not yet law, it is expected to become law pretty soon. We don't know which elements of it will be retained and which will be taken out. But I think most of it, we can expect that most of it will become law. And it's important to look at it at this time because simply because um, everyone is going to be filing their new H1 starting April 1st. And if the H1 gets approved, of course, then you're not affected by the regulation. So it's important that you file as soon as possible. But if it doesn't and it's pending, then and if the regulation is then published, then your H1 might get affected by it. So I think it's important to see what is needed, meaning how to file the H1 to avoid getting into any issues with reference to the new regulations, and what steps to take to ensure that your H1 is approved in light of the new regs, new proposed regs, I must say. Also, it makes sense then, if you're a company or even if you're an individual, to maybe file your H1 this year instead of waiting for next year. Or if you're a company and you're looking to, increase your number count, I think it'll be easier to file this year, because for next year, for sure, that new regulation will be in place, and it will be more difficult to file, and I'll tell you why shortly. So should I share the screen?
Absolutely, you can, Prashanthi, for sure. So, folks out there, it's a presentation you won't want to miss. So, explore the latest developments and regulations shaping the landscape of H-1B visas with none other than Prashanthi Reddy. The stage is yours, Prashanthi.
Thank you. Give me a minute. Okay. Okay, I think let me just share a window instead of sharing the entire screen.
Sure.
Sorry, guys. I'm technically deficient, so you have to bear with me.
Not a problem at all, Prashanthi. We are here to be with you,
Yeah.
and I'm sure you have a lot to share with us today. How
Yes,
has
I
it
do.
been, though, the past few days? Been busy after the H-1B lottery opened up?
Yes, it has been very busy. We are in the midst of filing registrations right now, and we're
Right.
hoping that all our registrations are successful. No one has issues.
For sure, for sure.
So, should I share the entire screen or just a window?
You can try sharing a window, but if you think that it is too much, maybe you can watch on the presentation yourself, but you can just enlighten us, guide us through each of the points in your presentation. I mean, that'll be fine.
Okay, now do you see my presentation?
Um, Actually, you're opened on your mail. So if you can share the screen where your presentation is showing,
Let me just
share
close
a
this.
window. On your window, you can scroll, you'll see the different windows that is opened.
Now do you see it?
Um,
Not yet.
just Yeah, share screen, then share window. You can see the different windows. So you click on the one which has your presentation.
I told you I'm deficient technologically. Okay, now
But
okay, now I see
yeah,
it. Now I see it. Now I see it. Now I see it. Okay, now you can see it,
yeah,
right?
yes, right.
Fantastic. All right. So this is just me, about me, and I'm skipping all that. Um, so first, I wanted to start with the visa bulletin because this is a new visa bulletin has come out, and I always like to talk about the visa bulletin when it comes out. So just a quick overview of what is happening with the April visa bulletin for all of you who have um, I-140 is approved, labor is in progress. You all know what a visa bulletin is. It comes out every month. It is published by on the travel.gov website. Just type in Google in visa bulletin and you'll see it. But the visa bulletin usually will always have priority dates and which dates are available for filing. So if your priority date is current on the visa bulletin, then that means that you will be able to file your 485, right? So that's what visa bulletin is. And your priority date is the date that you file your labor cert, in case if you're filing an EB2 or EB3, or it's the date that you're filing your I-140 if it's an EB1 and doesn't require a labor cert. Okay, so an EB1 is again, there are different categories, and we're only going to be covering employment based. But an EB1 is a visa category for a multinational executive, an L1A based, uh, or an EB1 can be extraordinary ability. An EB1 could be a researcher category. An extraordinary ability can be in the sciences, in business, in the arts, in sports, etc. So for
Right.
EB1, India has actually
Prashanti, like
advanced.
before we
Yeah,
just move ahead, can you just press F5 so that, it'll be full screen and viewers out there can have the full screen view of your presentation?
sure. There you go.
Yes,
Better?
thank you. Yes.
Now let me move it up and down. There you go. So EB1 is advanced by 5 months to March 2021. So that's a good advancement of almost half a year. China has advanced not much by 6 weeks, and all other current. So other than India and China, all other countries are called other countries, and they remain current. EB1 has been current for all other countries for quite some time now. EB2, India has advanced by 6 weeks, so not as much as EB1. China has advanced by 1 month, all other countries advanced by 7 weeks. EB3, India advances by 6 weeks, so almost the same as EB2. China has not advanced at all, and all other countries have advanced. 1 second, let me just Okay, advanced by 2.5 months to November 2022. So if your date is current as per the visa bulletin, then you can file your 485. This EB5, as you can see, this is for the investor visas, has not changed much. So if your dates are current as per this visa bulletin, you can go ahead and file your 485. In a visa bulletin, you usually have two tables. One is the dates for filing, and the other is the final action dates. This month in April, they are only going to be looking at the final action date table, which is usually a little behind when compared to dates for filing, because usually the dates for filing is a table that you can look at, where USCIS allows you to file in advance. Anticipating that your date will become current, they allow you to file the 485 in advance. But unfortunately, this month that's not available. So you will have to stick to the day for the final action date table. And I've just told you what that is for this month. Moving on to the meat and potatoes of what I wanted to present today. I wanted to look at a summary of the proposed regulations. There's some echo. I don't know if you guys are hearing it, but I'm hearing an echo. So anyway, I wanted to look at the summary of proposed regulations for the H-1B program, and that's what we were talking about just now. And I told you why I'm going to tell you now why it's so important to look at this point. So some of these regulations are things that USCIS has already been following as a matter of practice, but now they are being codified and made into a regulation so that no litigation can be filed against it, or even if it can be filed, they won't be as successful as they otherwise could be if it was not codified into a regulation. Okay, so the first point that they are wanting to codify is that any job that requires a general degree. For example, if you have a job that requires a bachelor's degree in, just say MBA, a regular MBA, and not specializing in, like an MBA in finance, MBA in marketing, etc., or if it requires just a Bachelor of Arts degree, for example, then such a job would not be a specialty occupation. Another example is if your job requires just any engineering degree and not a specific engineering, computer science or chemical engineering, mechanical, etc., then it would not be a specialty occupation. So they are seeking to codify that. That has always been, as a matter of practice, what USCIS has been following. But now they're, as I said, codifying it. The second point is generally USCIS will say that it has to be a bachelor's degree. Your job has to require a bachelor's degree in a specific field. And when it's not a specific field, if it's more than one field, they send out an RFE saying it's not a specialty occupation. But now, this is good news. They're saying that it could be your job could require a bachelor's in multiple fields of study, as long as you show that they are related. They may be different, but they have to show that they're related to each other and to the job as well. This opens up the possibility of filing a H1 for many more job titles than we previously had. The reason I'm saying this is because when they look at whether a H-1B qualifies for a specialty occupation or not, they look at a publication called the Occupational Outlook Handbook, which is available online. It's a publication published by the Department of Labor. So whenever the Department of Labor now in this publication has various job titles, so they look at that to see whether that job title is there in that publication or not. And if it's there, and if the job title, if that job says that industry standards is that the employers in this particular position generally require a bachelor's in more than one major, say physics, computer science, math, then USCIS will turn around and say that it's not a bachelor, it's not a specialty occupation. So now all those jobs which have more than one major, they'll still continue to be specialty occupation. They will now be specialty occupation, so that's good news. Opens up the H1 to many more occupations. Another point 3 is another good news, because now they're saying, previously USCIS would say that all employers always need to require a bachelor's degree for this particular position. And again, they go back to the OH, and if the OH says that most employers need it, but not all employers don't, they will send us again an RFE, and then they'll say that it's not a specialty occupation. So now they're codifying it. They're clarifying it. They're saying that it's only required that industry standard be normally, meaning normally employers should require it, doesn't mean that always employers should require it. So this is good because again opens up many more job titles even within the IT field uh, to be H1B approvable. And this is important because um, the job titles that we usually use, software engineer is software developer, is one of the most popular job titles, and the prevailing wage is high on this job title. And they've kind of shut down the other job titles that we use, like program analyst, systems analyst. The prevailing wage is much lower, but they've shut it down by saying it's not a specialty occupation, and mainly because of these reasons. So now it'll be more easy to use these other job titles as well, a computer programmer included, um, and prove that it's a specialty occupation. Be able to prove that. Um, Point number four, we know that H-1B amendments are required whenever there's a change in work location or job location. They're codifying it. They've been enforcing it as case law, based on case law, but now they're codifying the same thing. Number five, point number five, USCIS has always sought to give deference to existing policy, meaning if previously you had a H1 and if it's the same employer, same job, they should approve it without sending an RFE if you're filing an extension. But they don't do that. They don't follow their own policies often. And they send out RFEs even for extensions. So they are now codifying it and giving that deference policy to cover all non-immigrant petitions where the petition involves the same party and the same material facts. So even if you're filing an amendment, they should not be sending out an RFE for amendments as well. Number six, USCIS is saying that they are going to be asking for evidence of maintenance of status. This comes into play when you're filing an extension or you're filing a change of status. They want to make sure that you are in status presently before they approve the H1. And though they have done this previously as well, looks like they want to do this on every petition going forward. This is not necessarily good news, but it is what it is. So I suggest that we even in the present filings we provide evidence of status when we're filing the petition in the preliminary stage itself. Next point, the USCIS has said and continues to say that itinerary is not required. They're codifying it. They're eliminating the itinerary requirement. Previously, they would ask for a list of companies, especially if you're a consulting company, list of where you're going to be working for the next 3 years. And that was very onerous to be able to provide that list because sometimes employers don't know where they're going to be working after the next project is over. And that would really prove to be difficult to get the H1 approved. Now they're, because of ITSA versus Cessna, which is a court case which ITSA won against USCIS, they're not asking for itinerary requirements. Now they're actually codifying that and saying they won't ask. The next point is about validity period extension. So USCIS is going to automatically extend the validity period of the H1 beyond the period that you've asked for, especially if that period is already passed or very little a time of that period is remaining. This can happen when USCIS takes a long time to adjudicate a case, and especially if your time period that you've asked for is only a year. Also, it can happen if USCIS denies the case and then approves it upon appeal. At that point, at the time that it is approved, from that day onwards, they'll give you a year. Previously, they wouldn't do that, and even if you went through all the loops and got an approval, it was of no use because that, in some cases, that time period would already be over. Another important remedy that USCIS is seeking to do is for the F1s. We all know what F1 cap gap extension is. The cap gap extension is where you artificially extend your extension on an F1 until October 1st. So if you're on an OPT at the time of filing, even if your OPT is no longer valid, while the H-1B is pending, it will continue to be valid as per this cap gap rule until October 1st. Now they want to make that into April 1st of the next year, because this year, and the past years, when the H1 was never, sometimes the H1 is not approved until October 1st. It's approved after October 1st, in which case then, and they didn't have premium processing for cap cases in the previous years. What happens in that situation is F1 students will fall out of status come October 1st. They will no longer have the cap gap benefit. So they'll have to then either change status or extend their status on an F1 by taking additional courses. That's not required anymore because they've removed that October 1 deadline. Now you have until April of the next year uh, to remain in cap gap status and to wait until your H1 gets approved. So that's great news for students. This number 10 is very interesting because this is for all those entrepreneurs out there who want to start their own business but who are on an F1 or and want to move to a H1 through their own company, or are presently on a H1 and want to transfer H1 to their own company. Previously, USCIS would not approve these cases because they would say that there was no employer-employee relationship. It was difficult to show that because the employer and the employee is the same person. And also because if you are an employer, then you will do administrative tasks. And if you're doing administrative tasks, those are not specialty occupation. Those are not specialty occupation duties. So they said that you didn't qualify. Now they're saying even if you own more than 50% of your company and you're doing administrative tasks, as long as the specialty occupation tasks are more than 50%, you can still do administrative tasks and you can still get a H-1B approval. The approval will be for 18 months to start off with, and you'll get subsequent extensions in 3-year increments. So that's good news. And it's important. It's an important change in the H-1B rule. Moving on to number 11, FDNS site visits. Previously, you had the discretion to allow the FDNS officer into your premises or give them information or not give them information. Now you don't have that discretion. They want to make that compulsory so that you have to provide information to FDNS officers. You have to allow them into your workplace. So this is no longer discretionary. If you don't do that, they will simply revoke the H1. Even now, they could do the same thing, practically speaking. But now, again, they've codified this. They're saying you have to allow them in. If you don't allow them in, then they will revoke your H-1B for not cooperating with the FDNS site visits. Another important change is the rule that would codify the agency's long-standing practice of asking contracts at POs, especially again for consulting companies. They want to make sure that the job offered is a bona fide, non-speculative specialty occupation job, which means that in the last few years since the IT serve case came out and got approved in IT-Serve's favor, they have not been asking for POs and work orders and contracts. We filed many H-1Bs last cap without that, and they've approved all of them. Now they're saying, again, if this rule comes out, then those POs and work orders, they can ask for that again. We don't know to what extent they'll ask for them, whether they'll ask in every case, whether they will expect that you have a PO for the entire period of the H1, or they're just happy with a PO for 3 months or 6 months. So we have to wait and see to what extent they implement it, if they make it into a rule. Also, importantly enough, for those companies who are not physically present in the US, they have incorporated, they're doing their H1s, they're managing their business from India or some other country. They expect your physical presence now in the US, and they're trying to make that into a law. This is so that you can accept service, that's so that there is an actual person to accept service if there is a lawsuit filed against you, or if there is something that the USCIS files against you. They want to make sure that there is a person that is answerable here in the US. I think with that we are done and we can now proceed to our Q&A session.
Wonderful. That was very quick and to the point, just what you intended. And well, you were also speaking about the itineraries. So, uh, what are the itinerary requirements according to the list that you had mentioned some time back?
So basically, for the previously, what they used to do is they used to ask for a document which listed all the places that the beneficiary is going to work in the next 3 years. Because if you're filing a petition for 3 years, they want to know in advance where the person will work. And sometimes, especially in a consulting scenario, you could lose a project could be for 6 months, it could be for a year, it can be for 2 years or 3 years as well. So the employer, it's hard for the employer to know where they will be for the next 3 years. And generally, as per regulations, as long as you show as at the time of filing that you have a job for them, that should be sufficient. So it was overreaching of the USCIS to ask for this kind of information for the entire 3 year period. And that's why there was a lawsuit in which the ITSA won, and now they're not asking for it. And now they're actually codifying the fact that they will not ask for it any longer.
Right. So, folks out there, today we have none other than Attorney Prashanthi Reddy covering and unveiling the future of H-1B visas. And I hope you enjoyed the enlightening presentation. I'm very happy, actually, that we have so many comments and people asking questions already on YouTube, LinkedIn. So, I'll just greet all of you folks. Thank you so much, Amzad, Govind Mishra, Shivangini Srivastava, Pavan, Palla Pavan Kumar, Tej S, Ellie, Macbeth Dias, Meghana, Meena Michael, um, so many more. Nani, Raja Reddy. Well, I'll be very happy to take up your questions. Cobrin Rees, big hello to everyone. And I'm going to take up all of your questions very, very soon. But before that, we will go for a short break. And definitely, if you have questions to Attorney Prashanthi Reddy directly, you can even email her at prashanthi at reddyesq.com or visit her website reddyesq.com, and you can even call her on the number 212-354-1010. So don't go anywhere. Stay with us. I'll be going for a short break, and we'll be back very, very soon.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back, everyone, to Immigration and Jobs Talk Show. I'm Nipasa Pradhan, and today I'm very, very happy because we have none other than Attorney Prashanthi Reddy. She's here, with a presentation we just had with her. She gave us a short presentation on unveiling the future of H-1B visas, and it was very enlightening. She gave us the latest updates, and I'm sure all you folks also you have some questions, and you may want to ask. So we encourage our audience, to share your queries, if you have anything regarding H-1B visas, the proposed regulations, or anything related to the topic. So feel free to type your questions in the comment section and we'll do our best to address as many as possible. So, Prashanthi, are you ready to take up the questions?
I'm ready,
Oh, we
ready,
already
excited
have.
and ready.
Me too. We already have one on the screen from Amzad on YouTube. Just wanted to see what the implications on my H-1B are if I leave the US for a few years. I-140 is approved and H-1B is valid till December 2026.
If you're out of the country, then you're not in any status in the US, so you don't have to worry about status issues because you're not physically present in the US. Your I 140 will continue, even if it's withdrawn. You will be able to use your I 140 for the purposes of um, filing, of transferring your priority date. We talked about priority date earlier in the presentation. So you could, if you are filing through another employer, once you come back and you decide you want to file for another perm and I-140, you can transfer that priority date from this I-140 to the earlier one. So that, to that extent, it remains intact. And with reference to your status, that's not something you need to worry about if you're not in the country.
Okay. Traveling normally a problem like that otherwise?
So no, but I think what he's talking about is an extent staying outside the country, leaving the US, really, he says. He's not talking, I don't think he's talking about traveling. But if you are
Okay.
talking about traveling, then traveling is absolutely not a problem. If you're talking about leaving and coming back after a few years, then you could do that as well.
Mm,
If you're talking about traveling, then you leave and you have to have a visa to come back in. And in order to
right.
come back in, as long as you have a valid visa, you could do that. Either way,
Cool.
it's short
Cool.
term travel or long term.
Long term. Yes, definitely. I'm sure he meant leaving because he says if I leave US for a few years. So
Yes,
yes, I
yes,
think
there
he's
you go.
planning to
Yeah.
leave. Right. All right, let's move on to the next. I hope Amzad, you had your answer to your question. Um, this one's from Ellie. Can you highlight any significant trends or shifts in H-1B visa policy based on the proposed regulations?
We just spent half an hour doing that.
Yes.
So I'm sure it's recorded. Please listen to it. There is a lot of changes happening. My only tip to you is file sooner rather than later so that you're not affected by the changes because most of the changes are not good. So H1Bs is going to become stricter. Getting it will become more difficult. So I would urge you to file your H1 as soon as possible.
Right. And Ellie, hold up. After this session, we are going to post this whole session again, republish it, so you can watch through the whole thing and every detail. Um, this one is from V Rose, 2001. Can my husband file for amendment for H1, H4, and EAD together for change in place? Or he will file for H1 amendment first, then will apply for H4 and EAD before 180 days expiry.
You can, if your H4 is expiring, you should go ahead and file it along with your spouse, because if you file it with your spouse, as you seem to know already, that's why you're asking that question. If you file it with your spouse, then your H4 gets approved faster, and the EAD gets approved faster. And if you premium process, the spouse's case is premium processed, then your case is premium processed as well. As opposed to that, if you file it separately, uh, after your husband's H1 amendment gets approved, then it'll take about 8 months, 10 months to get the H4 approved. The EAD approved can take, the EAD can take longer. So yeah, I think you're on the right track.
Okay. All the best, Firoz. Let's take up another one. This one is from Macbeth Dyers. Cap gap ends on H-1B. Considering COS to B1 or B2, then H-1B with new employer. Is it common to receive RFE for B1, B2 during H-1B transfer? Is consular processing among common for H-1B?
Okay, I'm trying to understand because it's very cryptid. Uh,
Mm-hmm.
cap gap ends. Oh, cap gap ends. Maybe so. It's a change of status from F1 to H1. That's what cap gap means. For those of you who don't know, it took me a minute also. So if you're changing from F1 to H1, and so maybe I don't exactly know what the scenario is, but maybe his F1. If your H1 doesn't get approved by October 1st, as I was saying, as per the present rule, you have to file a change of status by October 1st. If it gets approved, you file premium processing. Now it gets approved, no problem. But if it doesn't, and I think that's what the viewer is asking, can he
Mm-hmm.
change to a change of status to a B1, B2? I don't see a problem changing B1, B2, and then again, um, getting a H1. Um, you might receive an RFE because they'll want to know what is your status, because they know that the cap gap gets over on October 1st. So you'll have to send them the B1, B2 receipt because you will not get an approval. So the problem with the change of status to a B1, B2 is the processing time for a B application is really long. They take 10
Mm-hmm.
months, 12 months for it to get approved. So you can't really wait for the approval. They'll have to approve your H1 based on the pending B2 application. You'll only have a receipt. So
Right.
sometimes they do it, and sometimes they'll say, oh, get us the approval, even though they have the approval. They're USCIS. They
Right.
want us to somehow magically produce the approval by the
What about the
RFE.
60-day grace period?
So 60-day grace period does apply in this context,
Yeah.
because after October 1st, you do have 60 days to change status. But if even after using the 60 days, nothing happens, then of course you'll have to change status to something else. Either extend your F1 or change status to a B1, B2 like this person wants to do. So
Mm-hmm.
in this situation, since the processing time is so long, you'll only get a receipt. You might get an RFE on your H1 saying that we are not able to approve the H1 since you don't have a pending status. We will approve your H1 for consular processing. So they will approve the H1, but they will not be able to give you an I-94. And so then
Mm-hmm.
you'll have to leave the country and then maybe come back on the H1B visa. Sometimes
Right.
they will approve it, sometimes they won't. So if you have no other option, then you should do it. But I think premium processing is a better option to do it rather than waiting for October 1st for the H1 to be approved in a regular processing.
Mm-hmm. Right. My team was saying maybe he probably lost his job and applied B1 or B2 using
Right, but
60 days
he talks about cap gap ends on H1. That's why I'm thinking it's not lost his job. It could be cap gap.
cap gap. Right.
So
So,
anyway,
Macbeth, maybe if you have further
we'll wait
questions,
for them.
yeah.
Yeah, we'll wait for them to clarify it, and if we have time, we'll do that. So
Sure, Macbeth, if
just
you have anything, you can, yeah,
yeah,
please
just for the future.
clarify your question.
Yeah, if you, I mean, there is no limit in the size that your question has to be, so don't try to make it too cryptic,
Too sure.
uh, too short, so we don't understand what it means. So.
Right, right, Prashanthi. Well, you were saying it's all bad news. I mean, many of the changes, all of the changes are bad. So why you're not very happy with the changes, is it?
No, because simply because a lot of H1s are used up by IT, and in the IT sector, a lot of H1s are used up by consulting companies. Um, in the consulting company scenario, for them to be able to show that they have a job at the time of filing the H1, It's difficult because the job actually starts 6 months later. So nobody will give them, it's very difficult to get a purchase order or a contract or a job set up for a person that, for a job that's starting 6 months later. Nobody, no client waits for 6 months. So it's like a catch 22 situation where they have to get something, but in order to get that, they need the H1, but the USCIS will not approve the H1 unless they have it, right? So that's why that particular um, regulation in the new proposed regulation is problematic and always has been. But I was just hoping it'll go away with, the IT Serve versus Cessna case, but it hasn't completely gone away. It's coming
Right.
back.
And this could be the doomsday news based on your 20 plus years of experience, Prashanthi.
Yes, I mean, it's not. It's not that we can't maneuver around it. I mean, people will still find ways of filing H1s, and they always have. So it's not as good as the situation is now. So all I'm saying is, file now rather than later. Make use of the
Okay.
advantages that you have now.
Let's keep that tip, friends. And let's move on to the follow up questions. Also, actually, we have Viro's following up, asking something. And he's asking, my H4 and EAD are not expiring until February 2025, but husband got extension until February 2026 for amendment. So, what
So
should
if
I
he
do?
already has the amendment approved, then there's nothing much you can do. But if he is filing the amendment now, you can still file for your H4 extension because your spouse is on. If your spouse is filing for his H1 or her H1 extension, then you can file for your H4 extension along with that, so that your I-94 and your husband's I-9. So again, and your spouse's I-94. I shouldn't be saying husband; it could be any spouse. And your spouse's I-94 expires at the same time. So even though
All
you
right.
have more than 6 months left on your H4, you could still file a extension along with your spouse if they are filing the extension.
Right.
If it's
So,
just an
Viro's,
amendment that they're filing, then there's not much you can do. But if they're filing an amendment come extension, then you should put your H4 extension there out there also.
yeah, no need to wait for the 180 days before expiry, right?
In this scenario, you
All
don't have
right.
to wait.
Okay. All right, Viro's, I hope you got your answer now then. Moving on, let's take up another one. This one is from Fagun Rai Tata. Um, is it too late to apply for H-1B for this year? I am working as a part-time employee for an employer who is willing to sponsor an H-1B visa. Is it possible? Currently, I am on STEM OPT.
No, it's not too late. File now. You have until March 22nd to do the registration. If the registration gets picked, then you'll be able to file the H1. So do it now. It's not too late.
Okay, Fagun, go get it done now. We'll take up another one. This one is from Benedicta. Hi, please, how much do I pay for H4 for premium processing?
There is no premium processing for H4. The premium processing is for the H1. And when you file it along with the H1, your case automatically gets premium processed. So that's the beauty of it. So you don't have, there is no separate fee. The H1 premium processing fee is there though, and it's increasing from April 1st to 2,800 and something. It's right now it's 2,500.
Yes, it's a huge hike. So just for H1. And now let's take up next one. This is from Namrata. Namrata is asking, STEM OPT ends 7/9/24. H-1B filed in January 2024. No premium processing. Question is that what would happen if H-1B remains pending until or after 7th of 7/9/24, my STEM OPT expiring date? What would be my options?
So I'm presuming that you are, we need more information here to answer this question. So again, we have to play this presumption game of presumption. um, so I'm presuming that your H1 is cap exempt, and that's why you're able to file it in January. Otherwise, you would not be able to file it until April, and only if it's picked in the lottery. So therefore, I'm presuming that there is no October 1st start date. So you will just have an immediate start date. And if both those presumptions are correct, then as long as you file before the expiry of your status, you will not fall out of status. So all you need to do is file before July 9, 2024, which you've already done. You filed it in January. So you just have to wait now for the approval or for the whatever decision is to come. If it gets denied, then you have to leave. And if the denial comes after July 9, 2024, there's not much you can do to change your status here. You'll have to leave as soon as you get the denial. If you get denied before July 9, 2024, of course, then you can attempt to file some other petition, change status, extend status, etc. But if it gets approved, and even if that approval is after July 9, 2024, you're still in status. After July 9, 2024, if your petition is pending, you continue to be in pending status. You don't have to leave the country. And if it ultimately gets approved, then you're seamlessly changing from an F1 to a H1.
Mhm. Okay. Well, let's move ahead with more questions. But we're already like 1 week down with the lottery open. How's the rush been? Any news? Maybe you can give us a sneak peek into it as well, Prashanthi.
Yes, so the first few days we had issues with the website and we were not able to do any lotteries last week. There was an
Mhm.
error message, but since then it's been fixed. And also, for those of you who may not know, that the browser makes a difference. We used a different browser and it helped. So if you're getting error messages, maybe try to change the browser. Also, the help desk, you can email the help desk if you're getting an error message. I think now sporadically we're still getting some error messages, but on the whole, it's been working well.
Okay. Well, some more time, and I'm sure the rush is going to be a lot, especially for the next few 2, 3 weeks.
Correct.
This one is
Yes.
from Shikha Gupta.
Actually,
Yeah,
next week is when the cap gets over. So next week we're going to see how the system will work because there'll be multiple petitions being filed, and it'll
right.
really be volume. And then we have to see whether the system will break down or
Mhm.
it's able to take that volume of cases being filed.
True. I just hope the system won't crash with
Exactly.
the rush.
Right.
Yeah. All right, let's move ahead with the questions, Prashanthi. And we have this one in LinkedIn from Shikha Gupta. Do I need to file H4 within the 60 days grace period of H1B?
Um, right. So if you are in your 60 days grace period and if you are on a H1, yes, absolutely. You have to file any change of status has to be filed within the 60 days grace period or while you're still on H1. Beyond that, you're out of status, so you cannot file any change of status. Then you have to leave the country and then come back, get a visa, a H4 visa, and then come back on a H4. And also, it's not a good idea to remain in the country when you're out of status because then if you leave, you may have issues getting any kind of visa.
Right, right. Well, I wonder how many people are having problems with the filing of H1B. But our company, Higher IT People, was able to file the first day itself. So we deleted all the cookies and we were able to go through the whole process very
That's
smoothly.
fantastic. See, that's the advantage of being tech savvy.
Absolutely. Shikha's asking, it's a follow-up. Is it difficult to go on H1B after converting back to H4 later, H1B grace period?
No, it's not. You are cap exempt anyway because you've already been counted towards the cap. So you can file for a change of status from a H1 back to from a H4 back to a H1 once you get your job.
Okay. All the best, Shikha. Let's move on. This one is the next question. Viros again. Um, my husband already applied for amendment and got approval until February 26th. But can I apply now separately for H4 and EAD, even though it expires in February 25th, or wait until 180-day expiry
I
until
think this
August to
is
apply?
this is the third or fourth question that's been
Right.
asked. So husband applied for amendment and got approval. Can I apply now? Yeah, of course you can. So now, if you have to apply, it doesn't make sense to apply now because you have to apply separately. And I think the 180-day rule now will apply to you. So just wait until the 6 month period and then apply for your H4 extension.
Okay, Viroz, I hope you have all your questions answered. I'm sure now you have no more doubts. This next one is from Navi on YouTube. At the time of filing for H-1B petition, when do H-4 dependents need to be applied for? Changing status from F-1 OPT to H-1B with dependents.
Okay. So you have to file along with your petition. So you have to file the H1 and H4 together. Please don't forget to do that. Simply because then they will fall out of status. Because once you convert from an F1 to H1, they will no longer be on dependent F1 status. They will be out of status. So you have to make sure that you file for both applications together.
Okay, Navi. Let's take up another one. Now, this one is from Harish Mora. I am currently on H-1B visa, which was approved in 2022. I am now applying for a new H-1B visa through consular processing. Will new H-1B visa be approved for remaining duration of the 6 year visa period?
It depends on how you file the new H1. If you were out of the country for more than a year, you can request for a new term of 6 years. But for that, then you'll be cap subject. So that means you'll have to file under the registration. But if you do not want to be cap subject, 22. So that's, yeah, that's recently. If you don't want to be cap subject, then and you are cap exempt right now, you just file a H1 for the remaining period. Then you will, yes, then you will get an approval for the remaining period that was unused on your H1. When you say period unused, it's the period that you actually were in the country working on a H1.
Okay, Harish, I hope you have your doubts cleared. And so does Viroz. She says, thanks a lot, guys. No more doubts. It's our pleasure, Viroz, really. Now, this one is from Pavan Kumar on Facebook. My bachelor's degree in mechanical, and I have 4 years experience in IT field in India. Am I eligible for H-1B cap?
Well, you should ask if you're eligible for a H1 because a cap is now different from H1B. So, yes, potentially. Again, it depends on what your job is, right? You haven't said, Pavan, what your job is, what job you're filing for. If you're filing for a mechanical engineering job, yes, you're qualified. If you're filing for an IT job, which I think you are, because you mentioned your experience in IT, 3 years of work experience is equivalent to 1 year of school. So you have 4 years of IT work experience. So what you need to do is get an evaluation done, work experience evaluation, and you'll most probably be evaluated to be equivalent to a bachelor's in information systems, which qualifies you to work as a H1.
Perfect. All the best, Pavan. I hope you apply for it. Benny Benedicta, please, I am new to your channel. Do you have sample visa interview questions for those of us new to this process? Well, Benedicta, we do have actually, and please watch our question and answer quiz videos. And you know what? This Friday, we have a visa interview show with a former US consular officer. So don't forget to subscribe to our channel and, hit the bell icon, so that you will be updated about the shows and you can definitely watch and be very much enlightened and have your doubts cleared as well. So thank you, Benedicta. Now let's have another one. Have we covered all? Tyson Mike on YouTube. I have done masters has filed and during filing my employer has filed my H-1B in regular cap instead of master's cap and it got picked. Will there be an issue during the approval phase if I have a master's degree?
No, it's no issue. You're lucky that it got picked, even though your employer made a mistake and filed it in bachelor's cap, regular cap. But there's no issue. That's up to you whether, which cap you want to do it. It's the other way around, and it would have been an issue. So if you filed in masters and you didn't have a masters, that would have been an issue. But you filed in bachelor's and you have, in the regular cap, simply because you have a masters, that doesn't stop you from filing in the regular cap. So there's no issue.
Awesome. So, Tyson, Mike, I hope you also have your doubts cleared. And thank you so much, actually, Prashanthi, for that lovely presentation and also for being so patient and answering each and every question from our viewers out there.
You're welcome.
So, folks, if you have direct questions to Prashanthi Reddy, feel free to email her at prashanthi@reddyesq.com. And definitely don't forget to visit her website, reddyesq.com, and call her in the number 212-354-1010. And thank you so much, Prashanthi, once again. I'm looking forward to meeting you again for another webinar. And
Absolutely.
I'm yes, yes. And since it's quite a big rush with the H-1B lottery, I think we will cover more subtopics under this topic. Let's see what can we cover in the next episode for sure. You have a great day ahead then, Prashanthi. Thank you so much for joining us.
Thank you.
Thank you. And folks out there, thank you so much also, each and every one of you in YouTube, LinkedIn, in Facebook. And remember, if you're looking for a project placement, you can even call us in the number 833-412-8472 or email us at support@higheritpeople.com. And well, we also deal with visas, E3, H-1B, OPT, green cards, everything immigration related. So feel free to contact us and drop in your questions in the comments below. This whole episode, this whole session is going to be republished. So definitely, um subscribe to us. And yes, stay updated because we will keep having more webinars like this with many attorneys and so many immigration experts who are only going to benefit you in many ways. So thank you so much for joining. And you also could email me at nipa@higheritpeople.com or call me or WhatsApp me in the number 408-335-6444 and visit our website www.higheritpeople.com. Thank you for joining. It's Nipasa Pradhan signing off from Immigration and Jobs Talk Show.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.